Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is what's coming next? Understanding the next big areas in the pharmaceutical antitrust wars. So pharmaceuticals, the pharmaceutical industry, the drug industry, have been a major area of focus for antitrust enforcers, both private and public. When you do an antitrust claim in this, do an antitrust case in this area, it's made particularly complicated because of two overlays. There's a complex overlay of food and drug regulation, and there's also an overlay of intellectual property that makes the whole antitrust analysis very fun and interesting. So every few years, new theories of liability emerge. And today we're going to speak with a lawyer who has represented pharmaceutical companies for many years through many of these battles, and we're going to hear from him what he thinks is coming next. My co-host is Anora Wang. Hi, Anora.
Hi, John.
Anora, what are we doing today?
Today, we're going to try to talk about several hot topics in the space of pharmaceutical antitrust. We're going to talk about reverse payment. Some people call it pay for delay. And then we're going to talk about product hopping, also very interesting. And then last, we're going to talk a bit about litigation strategy and planning from the defense perspective.
Great. Why is it important?
Well, two reasons, really. First, I think a lot of discussions on affordable care or maybe just drug price can easily get sensationalized. While in reality, there is a lack of understanding of the conduct of the pharmaceutical companies as compared or measured against antitrust laws. And then second, as you have already previewed, this is a very dynamic and active area. So it's best that we learn from someone who is leading in this area.
Yeah, pharmaceuticals have always been controversial. I remember back to a few years ago, and I had a pharmaceutical client and was talking to them about the atmosphere in Washington, and I basically told them the only thing you have going for you is you're not a bank. So pharmaceuticals have always been in the crosshairs, and I think it'll be good. I think they'll continue to be, and that's why we want to learn more from our guest. And who is that today, Anora?
We're fortunate enough to have Eric Grannon, who is a partner at the law firm White & Case, and he has extensive experience in pharmaceutical antitrust cases, obviously, and then including specifically settlements of pharmaceutical patent litigation between branded and generic. That's what we're going to go a little in depth today. And then previously, Eric had served as a counsel to the Assistant Attorney General in charge of the DOJ's Antitrust Division. That's when that's around 2003 to 4. And then Eric has also served as a special assistant U.S. attorney in the District of Columbia, where he has tried an impressive number of bench and jury trials as lead counsel.
All right. Well, let's bring in our guest. Eric Grannon, welcome to the program.
Hey, well, John and Anora, thank you very much for having me. This is my first podcast, and I'm looking forward to it.
That's great. I'm so glad that you choose our Curious Amalgam as the platform for your first podcast. Welcome.
Well,
before we dive into the specific topics, I think perhaps it's beneficial to our listeners to sort of get a big picture view of the antitrust enforcement involving pharmaceutical companies. Have you observed perhaps throughout your career or even your knowledge of even decades before that, has there been an increase of enforcement, at least in the U.S., scrutinizing the conduct of pharmaceutical companies?
Well, I'll give you the one-word answer is yes. The essay answer is, I think your point about looking back a couple of decades is kind of spot on, because I'd say pharmaceutical antitrust as a distinct area of the law is about 20 years old, maybe a little bit older, and that it kind of grew up in the late 90s, both with some private cases as well as government enforcement. It really took off as not only a distinct area, but one that was very active when the FTC brought its first pay for delay or reverse payment case against Shearing Plow and Upshur Smith around 2001. And that, kicked off, a spate of different private litigations concerning other pharmaceutical patent settlements that were brought by the class action bar, as well as numerous FTC investigations involving other settlements as well. And it was a very, very hot area of the law for, more than 10 years, with some divergent results around the country, leading to the Supreme Court's decision in the area called FTC v. Activists in 2013. And basically what that case did, and I'm sure we'll get to it in more detail, it kind of said, okay, reset, we're going to do a do-over. All of this is going to be subject to the rule of reason. These competing tests that have come before us, we're not interested in those. We're just going to go back to first principles and have it go under the rule of reason. And that case in particular, I think, made companies a lot more conservative about the settlements that they would enter, because they knew under the Supreme Court's decision, they would be subject to the rule of reason, under which it's very difficult to win a motion to dismiss. And so that was kind of like a pivot point, I'd say, in around 2013 or so. But again, just talking big picture, I'd say even though companies became more conservative in their conduct, you had a whole, I'll just say, cadre of lawyers on the plaintiff side in the private bar as well as the government who are now specialists in this area. And had learned the issues, had kind of learned the overlays that John talked about in the intro. They'd learned the FDA issues, they'd learned the patent law issues, and kind of having acquired that specialized knowledge, they were, apt to apply it in looking for new theories of liability. So it's been a very dynamic area, because even after the Supreme Court's decision basically kind of set the rule, all of these enforcers and private plaintiffs I was talking about said, okay, well, now we're going to go out and bring other kinds of cases, even if you companies in the industry conform your behavior to the Supreme Court's standard.
Right. So I think you already mentioned FTC versus Activists, which is a watershed or landmark case. Before we go any further into that case, perhaps let's start with the principles. Like, what is reverse payment or pay for delay? What is the fundamental allegation of a pharmaceutical company's conduct there? I think better start with what's reverse? What's the payment reverse to resolve what? Maybe you can briefly explain to our listeners what's the fundamental allegation of a reverse payment case.
Okay, Nora, I think you're right to kind of step it back for the audience, because I know that if I were just learning this in law school, for example, I find it very, very, very complicated, because you're talking about an antitrust claim that's being brought to test and scrutinize the terms of how a separate litigation, an underlying patent litigation, how that case is settled. So let's give an example. So I'm a pharmaceutical innovator, and I've got miracle drug X. I'm in a patent litigation with a generic challenger, and that generic challenger is saying, I can make a copy of X that delivers the same medical benefits to a patient in a way that either does not infringe your patent, or I'm going to argue that your patent is invalid for a myriad of reasons. So what happens is sometimes those parties settle that patent litigation, and what they'll do is, let's say the key metric in all of these things is how much time there's left on the patent for whatever the pharmaceutical product is. So let's just say, for sake of example, it's 2020 now, and then the relevant patent expires in 2030. The parties might say, okay, well, let's settle this patent case and we'll split the baby. You, generic, can bring your product to market under a license that I'm going to give you as the pharmaceutical patent holder in 2025. And so that's 5 years early entry. And that's like the most basic sort of example that you can think of. But what if they say, okay, the generic says, okay, that's great. I can bring my product to market 5 years from now. That's 5 years earlier than the patent expires in 2030. But how am I supposed to keep my lights on at my company between 2020 and 2025? This is my only generic product that I have. How am I supposed to survive as a company? And the brand company says, well, what else can we do together? You're a much more efficient manufacturer than I am. And that's just a general rule of thumb in the pharmaceutical industry, is that brand companies spend most of their time focused on research and development. Generic companies are not doing that research and development in that way. So they focus on becoming really efficient manufacturers. So the brand company might say, why don't you manufacture this product for me, because you can actually do it more efficiently than I can. And I'm going to pay you now to be my manufacturer. And they hash out the terms of whatever that supply arrangement is. What happens is either a third party private plaintiff or the FTC might say then, that so-called side deal that you've done, that manufacturing deal, is somehow blowing on the dice of the terms of your license agreement. So you agreed to entry in 2025 with that supply agreement, but we say if you had not given that financial inducement of that supply agreement, you actually would have entered, you would have granted a license to enter in 2024, 1 year earlier. And so we're going to allege that 1 year delta under our allegation is the purported delay, and that your supply agreement was the pay for delay. And the idea of why it's called reverse or labeled reverse is that in a typical setting, when a patent holder allows a licensee to come to market, the licensee ends up paying a royalty back to the original patent holder. The thing that's different about pharmaceuticals is that with generics, the way they come to market, you don't actually sell them before the litigation. It's a litigation really about the formulation versus whatever the patent is on the product that the innovator has come out with.
So I just want to understand, because this is confusing to me. I want to make sure I understand. So what you're telling me is that the branded company they've agreed, they figured out what the settlement is, and they've come to some sort of fair settlement for an early entry, like you said. But the branded company is giving money or something of value to the generic company. And doesn't it have to be that extra value? The trade-off is an earlier, a later entry period for the generic, so consumers get the drug later, right?
Yeah.
Isn't that just buying? Isn't that just buying time, which means basically buying a non-compete for a longer period of time? Isn't that wrong?
That's the allegation. That's the allegation. The flip side of it is, what if that supply agreement is fairly valued? And that's kind of where the Supreme Court left things under the activist decision. You actually still can do business at the same time as a settlement. You have to be prepared, obviously, for the scrutiny that can come from a litigation. But if you can prove that the so-called side deal is on fair terms, that the same terms that the parties would have entered in any other arm's length agreement, then the parties could actually prevail. So to answer your question, I want to try to answer your question, John, because I think what you're saying, there's something intuitive about it. But to get back to the point that I was making before, the generic company could look forward to, let's say, coming to market in 2025, but it does still have the reality of, okay, well, what do I do for the next 5 years?
All right, Eric, then let me ask you a different question. Suppose you went and played out the patent litigation, and suppose the branded company won. That means that the generic company wouldn't come onto market until the end of the patent. Doesn't that mean that anything before the end of the patent is going to be good?
Well, there were two tests that went to the Supreme Court in the activist case in 2013. And the one that had been predominant for years was called the scope of the patent test. And basically that test said any settlement that the parties enter that does not exceed whatever the length is of the patent or go beyond kind of what I'll just call kind of the scope of what the patent actually covers is pens down for antitrust. And that was a very deferential standard for defendants, and many cases were resolved on motions to dismiss. So that test kind of embraced what your question proposed. I think the other way to look at it, to be fair, is, and this is why the Supreme Court went the way that it did, is, by the way, that case, an activist went up on a motion to dismiss. So all the allegations were accepted as true. In that case, the FTC alleged that hundreds of millions of dollars were provided in inducements to the defendants, to the generic defendants, to settle on terms that they would not have settled for. So I hope I'm answering your question, but basically antitrust is broad enough to kind of determine and test whether an inappropriate consideration has been provided, but antitrust is not able to say, well, you know what, in this case, the brand would have won the patent litigation anyway, therefore any entry prior to the patent expiration is kind of to the good of consumers and a pro-competitive benefit. We're not able to kind of redo the patent litigation to figure out what would have happened absent the settlement.
So, all right. Go ahead, Anora, go ahead.
I hope that, John, did that get to the point that you were trying to get at?
Yeah, I was just this whole thing is confusing to me, Eric.
I'm going to try to clarify it to the best of my ability in this interview.
Well, this is inherently complicated. That's why that's so interesting. I think let me try to summarize a little bit, simplify and hope not oversimplify it for our listeners. So the Supreme Court held that in FTC versus activists that all of this, what we have discussed, including efficiencies from the side deal, or perhaps the strength of the patent, should all be looked at, and then it's all going to be analyzed under the rule of reason rather than some more fast track or straightforward standard. Is that right, Eric?
Yes. So again, the short answer is yes, and I'll give kind of the essay answer. And I hope this will be the only thing that I actually read during this interview, but I want to read the Supreme Court's quote. The Supreme Court said, quote, where a reverse payment reflects traditional settlement considerations, such as avoided litigation costs or fair value for services, there is not the same concern that a patentee is using its monopoly profits to avoid the risk of patent invalidation or a finding of non-infringement. So when the Supreme Court sent that case back to the district court and just opened the floodgates for, I'd say probably more than 50 different reverse payment and pay for delay cases have been filed since the activist case, it was saying, we want you district judges to kind of, figure this out on a case-by-case basis. We're not going to go with the scope of the patent test that had prevailed before the Supreme Court decided it, nor did the Supreme Court adopt the FTC's proposed quick look presumption, which would have really condemned presumptively any alleged reverse payment. We said, the Supreme Court saying, we want you to figure out on a case-by-case basis.
Right. And then one more question and quick. So is that true that after activists, we're seeing more novel or interesting allegations against pharmaceutical companies? So
I'd say that, the pharmaceutical industry in particular, because you're dealing with, big ticket products, some of which, have sales of, north of $1 billion a year. They're very sophisticated as an industry in terms of, adapting to what's happening in the law and taking in court decisions and modifying their behavior. So I would say, even leading up a little bit before activists, but certainly since activists, companies have become much more conservative in the types of settlements that they'll enter. So whereas, let's say 5 years before activists, it would have been very common, to use the example I gave earlier, for a brand company and a generic manufacturer to enter a supply agreement at the same time as a settlement. That was a very common way to kind of bring parties together because there really are efficiencies. Generics tend to be much cheaper manufacturers than brand companies. So that was a common way to kind of exchange consideration in a way that was that made sense for both parties. Now, post-activist, I would say it's very rare for parties to do that. Not because it doesn't make sense for them to do it, but because they know they're going to be opening up a can of worms for themselves in terms of antitrust litigation, either from the class action bar or an investigation by the FTC. So because companies have become more conservative, and I don't mean this in a pejorative sense, I think there is an element of here, like, fish gotta swim. And what I mean by that is the government enforcers, the FTC has, predominant jurisdiction in this area. The FTC enforcers and the private lawyers have learned all the issues that I talked about before, right? And they've learned the FDA regulatory framework that John mentioned. They've learned the patent issues. They know how these things work. And so they take that knowledge, and that's their lens for looking at other types of conduct. And so they come up with new theories.
So this is super helpful. Let's just to make sure we keep going. Sounds like reverse payments, we're seeing a slowdown. We'll keep watching that. Let's talk about another issue, Eric, product hopping. Very briefly, tell us what is product hopping.
Okay, well, the basic allegation in a product hopping case is that the brand company has, I mentioned Miracle Drug X before. Let's say they've got Miracle Drug X and that patent is going to expire in 2020. Just as the patent's about to expire, they come out with Miracle Drug X2, which has got some other benefit for patients, maybe less side effects, or it's easier to take, or maybe you only have to take it once a day as opposed to twice a day. It's got some improvement to it. The plaintiffs in these cases, either the government or private plaintiffs, say, well, that improvement really wasn't much benefit to consumers, and all you're trying to do is to force consumers to buy that new product, which is under a new patent, which has a farther out expiration date than your old expired one. And you can therefore charge consumers a higher price for it because you're not going to be subject to generic competition on that new product. That's the basic framework.
So wait a second, I don't get that. So you're telling me that a company can't choose the delivery mechanism for its pharmaceutical product?
Well, again, that's the allegation. So here's the thing that makes those allegations successful, and some cases have been successful and some have failed, but the thing that makes it successful is the plaintiff can show that the drug company did something to coerce consumers into switching to the new product. And it's a little bit specific to the pharma industry because we're not just talking about like a better iPhone or a better widget or something like that. In the pharma industry, generics in most states are automatically substituted for whatever the brand name drug is. And so if the pharma company takes some step to thwart that automatic substitution, for example, they come out with, I said, Miracle Drug X2. Let's say the pharma company not only stops marketing the prior version, Miracle Drug X, but completely withdraws it from the market. And in fact, takes out, there's something called NDC codes, takes out the codes so that it can't even be prescribed anymore. That type of step is what's called a hard switch. The company is alleged to then be forcing consumers to use the new product. Hard switches are dangerous for companies in this area and can lead to some serious antitrust scrutiny and potential liability. If they just take what's called a soft switch and say, okay, well, we're going to come out with X2. We're not going to spend any money marketing X anymore, but we're going to leave X on the market so that generics can basically piggyback on that. And then we'll let consumers and patients and doctors choose whether they want to switch from X to X2. If companies do that, generally they're going to be okay.
So, okay, so I get it. So what you're saying is it's not just that they're switching in a new delivery mechanism or something more innovative. It's that the allegation is the companies are playing games with the regulations, the automatic substitution, and trying to prevent that from continuing. And if you don't prevent that from continuing, it's a lot less risky. Do I have that more or less right?
Yeah, you've summed it up, and we're truncating this discussion, which I think makes sense for this format. But what we're cutting to is like what makes a product hopping case viable. And what I'm trying to say here is that many product hopping cases are brought even when the pharma company hasn't done anything inappropriate at all, and it's just plaintiff saying, "Hey, you came out with this new version that we don't think is actually, valuable to consumers at all, and so we're going to sue you over that." What I'm trying to cut to the chase with you and your question is what actually makes a viable claim. And so there are many product hopping cases that are brought when the pharma company hasn't done anything inappropriate. And I actually think most pharma companies now have quickly absorbed the law and understood that they can't do things to coerce consumers to switching to the new product. What we haven't hit on at all here, and I think might be informative to the audience, is these cases don't turn on kind of measuring how valuable the whatever the benefit is of the new version of the drug. Right. And to unpack that, there's not really an existing ability, at least in antitrust law, to basically test whether, this X2 is actually that much better than the X product. That's not what's going on. It's all the cases turn on whether the company has done something coercive to force consumers to switch.
All right, our crystal ball. Where do you see things going with product hopping?
I think there will be continued litigation in the area for sure, but I do think big ticket, almost like very akin to reverse payments. I think that again, pharma companies are very astute observers of the case law in this area, and they kind of know what not to do. They know what the third rails are. So I don't think we're going to see, there were, if you look back at some of the older cases, there were actually allegations that were, proven of pharma companies, let's say, for example, actually buying back their own product from the shelves of retailers to again, take that step to inhibit generic competition. I don't think we're going to see that kind of thing. I think we're going to see companies be a lot more careful about how they introduce new products and not do it in a way that actually inhibits the sales of the older product. Even though they are not compelled, they have no duty to aid their competitors in antitrust law. I certainly, they're going to stop marketing the old product and spending dollars for that. But I don't think we'll see the egregious allegations that we've had in the past.
All right, let's go on to issue number 3. Class certification. What's going on there?
So I think we mentioned at the outset that basically pharma antitrust is about 20 years old. A little bit longer than that for private litigation. For the large majority of that time, it was almost a given that in every private case a class action would be certified. And both for direct purchasers of the product as well as indirect purchasers. And the direct purchasers would basically be the pharmaceutical wholesalers and retailers of whatever the drug product is. And the indirect purchasers would be the end users. And a lot of time those claims are brought by like insurance funds that actually have to pay for the products that individuals use. But we've seen very, very recently in the past, I'd say just 3 to 4 years, a really recent trend of classes being denied, class certification being denied, both for direct purchasers and indirect purchasers for a variety of different reasons. For direct purchasers, sometimes because just lack of numerosity, that when you really drill down and look at the number of direct purchases of the product, you're only talking about a couple of dozen companies. And that's not enough. Some courts have held to justify a class. For other reasons as well, courts have started to scrutinize some of the, in a class case, you're basically supposed to have common proof. You're supposed to be able to say, okay, well, here's the evidence, and it basically applies to all the different claimants because they're so similarly situated. But when you really drill down on it in some of these cases, the companies are not all that similarly situated. They're big, sophisticated companies that are the plaintiffs, and they've got individual contracts that they negotiate with the drug sellers, and they got different terms. Another thing that's been looked at is on the patient side, on the indirect purchaser side, there's, for certain products, a very substantial number of them who won't switch to whatever the generic is. They're called brand loyalists. And so what the courts have said is, wait a minute, if you've got some substantial number, let's say 10% of patients who are not going to switch to the generic, how can you kind of come in with these allegations and say, well, everybody would have switched and benefited from this lower price? So I would say overall, courts have just become a lot more thoughtful about certifying classes in this area. So I think we'll continue to see a lot of scrutiny.
And you're seeing this in the Supreme Court in non-pharmaceutical cases, right? There's several, the trilogy of class action cases. I do agree with you, Eric. I think the vanguard on this has been some of the pharmaceutical cases, because I think some of the issues that the Supreme Court highlighted are probably put into sharp focus in pharmaceutical cases.
Yeah, I agree with that. And I think the thing that has maybe really teed it up for the pharma cases is, in most of these suits, we're talking about a hypothetical event. In some of the cases, they go on long enough where the generic actually comes to market, so you can actually look at actual sales data and see how much market share the generic product steals from the, or I shouldn't say steals, but how many patients convert to the generic. But in most of the cases, you're talking about a hypothetical event that has not occurred, and the plaintiff is saying, well, this entry date would have been whatever it is, 3, 4, 5 years sooner than the parties agreed to, but that date still has not come. So each side puts forward their experts to say, okay, well, here's what would have occurred had generic entry, actually taken place. And in that case, the defendants, the pharma companies are likely going to say, well, not everyone would have switched. And the plaintiffs are going to say, well, everyone would have switched. Every single patient would have switched to the generic, and therefore they all would have benefited from this lower price. So I guess I'm agreeing with you, but I think in particular that it's an area that's been ripe for additional scrutiny, because the underlying dispute is a hypothetical event.
All right, crystal ball. Where do you see class actions going in the next, in the near future?
I would say I think we're going to continue to see some hotly contested class cert cases in this area, because I think in general there's still a body of law that is, I'll call, plaintiff friendly, but these recent cases that have come out have really started to turn the tables, and defendants are winning even at the circuit level. So to tell you the truth, I actually think this is going to be kind of the most important part of these pharma antitrust cases for, probably at least the next 5 years, maybe the next 10 years. And the reason I say that is because on the merits of these cases, very few of them actually end up going to trial. If, just for practical purposes, if the defendants lose summary judgment, they tend to settle because there's so much at stake. All of that said, by the way, I can't kind of let this opportunity go by, being a defense lawyer, and without mentioning, for all of the scrutiny that's been in this area, all the cases going to the Supreme Court, all that stuff, still to this day, not one judge or jury has actually ever found that any individual pharmaceutical patent litigation settlement violated the antitrust laws. And it's kind of a remarkable, observation that I think in this area, for all of the scrutiny, when you actually look at it, the few cases that have actually gone to trial, the defendants have always prevailed. And I think that does go to show that these cases are very complicated, and there's risk to both sides in going to trial. And so that's why I think you see a lot of settlements. Before you get to settlement, though, one of the key sort of leverages that the plaintiff side has is if they can get a class certified. So basically, summary judgment, class certification are the two big kind of inflection points in any of these private cases. So I hope I'm answering your question, but I think this is where all the shooting is going to be in these cases, more so than any other area. For, I'd say, again, 5 to 10 years is going to be on class cert. And I don't think that's the kind of issue that's going to end up going to the Supreme Court, for example. So we could see, lots of very interesting different outcomes all around the country.
All right, well, let's shift gears. This is super helpful. Let's shift gears, Eric, and I'm going to ask you the hardest question that you're going to get in the entire podcast. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Okay, so you're not going to believe this, but when I was 7 years old, I decided I really wanted to be a reverse payment lawyer, and just design. No, it's obviously nothing could be further from the truth. So interesting. I'd say that one of the kind of quirkiest reasons that I do what I do, and I became a lawyer, and that in particular that I'm a litigator, is because I was really into chess when I was a kid. It was a big part of my life when I was in elementary school in particular, and played in tournaments, and it really was, it was the focus of my, extracurricular activities. I played a lot of chess, and I think that I like the, competitiveness of it. I like that, every time you sit down at a chess table, you're in an equal playing field with the other side, and you bring to the table whatever you got, your experience, your ambition, your intensity, whatever it is, and you try to win. And I see a lot of that in my personality and how it plays out in these cases. And you're trying to convince, a judge or a jury, but for a lot of the time, you're trying to convince a judge to see things your way on whatever the issue is. And I guess in my head, I see that kind of rubric that we have in these cases as a lot like a chess game.
Did you play with one of those chess clocks?
Yes. Yes.
Why is it when people play chess, I always feel like they're slamming their chess clock and making a really loud noise? Is that part of it? Is that a thing? Is that coached?
I think I can say this since I was a chess player, but chess is kind of a weird world, and there is an intensity to it. But yeah, the tapping on the clock that people do back and forth, I don't know whether that's sort of a chest pounding that goes on, but yes, it is funny. It is very funny. I have to tell you, there's a chess variant called Bug House. And that's basically a tandem game where you have two different chess matches going on at the same time. And you can actually take pieces from one game and put them onto the other one. I've actually seen people get so upset playing that they actually throw the entire chess set, pieces and all. So, I mean, you wouldn't think of it as like that kind of thing. But I guess that's the equivalent of somebody getting kicked out of like a baseball game or something like that.
Is there a lot of trash talking in competitive chess?
Yes. So you use a lot of different terms, but the one that's particular to chess, and I actually don't know the derivation of it. Maybe it's Yiddish or Russian or something. But the worst thing you can call someone in chess is a potzer. And you're basically saying that the person is an idiot. They don't know what they're doing, and they basically shouldn't even be at the board with you. So. That's the four-letter word in chess is potzer.
Potzer. Anora, make a note.
Yeah, I did.
No more calling people potzers. Okay.
I thought it was a compliment.
Yeah, I thought so too. My Yiddish isn't so strong. But now let's go to our final segment, which is the Curious Hat.
And now it's time for the Curious Hat.
When we are all together, I have an actual hat from which I pull out an actual question, and we ask the actual guest what that actual question is, and they answer. It's done at random. Since we are not all together, I am wearing a hat, and I have a list of questions numbered from 1 to 25, and I'm going to ask the guest to choose a number, and we will ask the question that corresponds with that number. So, Eric, choose a number.
I guess all roads lead to activists, which was decided in 2013. So I'll go with lucky number 13.
Lucky number 13. Okay. If you couldn't live in the country where you do live now, I believe that's the United States, what country would you live in?
Ooh, what country would I live in? Well, I guess a lot would go into that, whether I still had to work or not. But the first thing that comes to mind is the south of France. I've never gone there, and I was really hoping to go there this summer. But obviously, with everything we're dealing with, that's not going to happen. White & Case has an office in France, so maybe I could actually manage to work from there. But if I could just go anywhere and not live in Maryland, it would be the south of France.
So let me get this straight. The country you would live in is a country you've never been to.
No, I've been to France. I haven't been to the south of France. I've been to Paris and loved it. But yeah, it's just I would take that risk, John. I know that it does sound a little funny to say that, but yeah, if you're going to say, plot me anywhere indefinitely, it would be the south of France.
And how is your French?
Of course, I don't speak French.
Eric,
I have to survive on my antitrust skills, and I guess I'd have to play chess to survive.
Yeah, but you could go pro. I mean, I just want to warn you that there's a real possibility that if you followed that out, you could very well starve. Because they don't, as I understand it, if you don't order in French, you may not get fed.
Well, when I get there, I'll figure it out. But that's the first place I'm going. I got to tell you, when all this travel restrictions are through, it's the first place I'm going.
And it sounds like an awesome place. Well, Eric, thank you very much for being with us, and we will see you next time on Our Curious Amalgam.
Hey, thanks for having me.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.